Please be advised that all immigration court hearings for immigrants who are not detained are canceled through at least June 26, 2020. This presentation is part of a series of video trainings put together by the Urban Justice Center's Domestic Violence Project. This training is on Special Immigrant Juvenile Status, or SIJS. This training is designed to provide general information about SIJS. It is not intended to provide legal advice or guidance on any particular case or matter. When in doubt, consult a lawyer. Special Immigrant Juvenile Status, or SIJS, is available for children who are under the age of 21, are unmarried, have been abused, abandoned, or neglected by one or both of their parents in their home country, and who it's not in their best interest to return to their home country. Once a child is granted Special Immigrant Juvenile Status, they are eligible to become lawful permanent residents if a visa is available. Visa availability is dependent on the child's country of origin. Obtaining SIJS is a two-step process. First, there is a state court proceeding. In New York, that state court is often the family court. Once the state court proceeding is completed and the child has obtained the necessary orders from the court, they can then file their SIJS petition with the United States Citizenship and Immigration Services, or USCIS. In order to be eligible for SIJS, a child must be found to be dependent on the state court, which in New York would most likely be the family court. Dependency on a state court is most commonly found in guardianship, custody, neglect, adoption, PINs, and juvenile delinquency proceedings. The state court must also issue a special findings order, which states that the child cannot be reunified with one or both of their parents in their home country due to abuse, abandonment, neglect, or some similar basis, and that it is not in the child's best interest to return to their home country. In New York, courts consider a child to be abandoned if 6 or more months have passed without substantial contact between the child and parent. Also, New York courts may consider domestic violence committed in front of the child to be neglect. If the parent in the home country has passed away, the court can determine that the child cannot be reunified with that parent. That would fall under the some similar basis category. When determining whether it is in the child's best interest to return to their home country, the courts look at a number of factors, including who would be caring for the child in their home country, the financial resources of that caretaker, access to education, the presence of gangs and the crime levels in the home country, access to quality health care or needed medical resources, and any other relevant factors. After the child is declared dependent on the state court and receives the special findings order, they are able to file the I-360 self-petition for SIJS. This is a fairly straightforward process, and the child must provide the state court documents as well as verify that they are under 21 and unmarried. A child is still able to receive SIJS if they turn 21 after filing, so long as they were under 21 at the time of filing the self-petition. If a visa is currently available for the child's home country, the child can file an application for lawful permanent residency and work authorization concurrently. This allows the child to receive their work authorization while their SIJS self-petition is pending. After the SIJS petition is approved, the child is eligible to become a lawful permanent resident. If the child filed their lawful permanent residency application along with their SIJS petition, USCIS will automatically move to adjudicate the lawful permanent residency application. If the child was not able to file the lawful permanent residency application concurrently, they must wait until a visa is available before they can file their lawful permanent residency application. The United States places quotas on the number of visas available annually for certain countries, including El Salvador, Guatemala, and Honduras. Many children applying for SIJS are from these countries, and they may have to wait many years for a visa to become available. It is important to note that after a special immigrant juvenile becomes a lawful permanent resident, they can never petition for their parents. With a green card, the child can travel outside of the United States more freely, can be eligible for federal financial aid and other public benefits, and after 5 years can naturalize and become a U.S. citizen. I hope that this video tutorial has been helpful and informative. As a reminder, the information provided here is general and is not intended to be a substitution for legal advice on any particular legal matter. As always, when in doubt, ask a lawyer. Thank you for watching.